Welcome to the Silicon Flatirons annual Content and Intellectual Property Conference. My name is Amy Stepanovich. I hesitate to say I am the new, because I don't know if I can claim new anymore, Executive Director of Silicon Flatirons. My vision for Silicon Flatirons is a center that catalyzes the creation and development of inclusive and innovative law, technology, and entrepreneurship. Our mission includes convenings, much like the one you are at or viewing remotely today, support and embracing the heart of the center, which is our students, many of whom are in the audience, and supporting our community both here in Boulder, in Colorado, and around the country and the world. Intellectual property and copyright have been a key part of Silicon Flatirons for a large part of our 20-year history, and I'm so proud to be here today and to be able to not only get to host, but also actually watch the content of the conference that we're having. I want to start by just a few quick thank yous. First and foremost to Kristelia García, who you'll be hearing from momentarily and who I get to introduce, to our speakers, to our moderators, to our supporters, to the rest of our faculty, some of whom are in the room, to our amazing staff. A special shout out to Vanessa Koppel, who is back here in the back and who has helped put together the entire event that you're going to see here today. And to the students. If you're a student at CU, can you raise your hand real quick? This is just an amazing turnout. We're going to continue to remind our moderators that our rule for Silicon Flatirons events is students get to ask the first question. And we're really passionate about the students that we're able to host and help prepare for future careers. And so with that, I'm going to turn it over to Professor Garcia to let her intro the conference more formally and to thank her again for everything that she does to make this happen. Thank you.
Thank you, Amy. Hi, everybody. Good afternoon. I'm Kristelia García. Welcome to the 6th annual Content Conference, now hosted by Silicon Flatirons here at Colorado Law School. It has been such an amazing opportunity for me to host this conference every year in its various iterations, coming in first as a brand new law professor out of the music industry, trying to convince people that these were conversations worth having. And now as a nearly tenured professor, I feel so incredibly grateful to be able to run this series and to bring in friends and colleagues and people that I admire to talk about issues and to get together and nerd out about these things. And there's so many people to thank. I'd like to start by thanking Phil Weiser, who started this center 20 years ago now and had enough faith in me to hire me and let me run this at the time was a new initiative. To our fearless leader, Amy Stepanovich, you just heard from, who demonstrates daily that women don't just do law and tech, but excel at it. And I think that's excellent for our students as well. And of course, the peerless staff at the center, Vanessa Koppel, Heather Martin, Nate Mariotti, our symposium editor and master cat herder somewhere here, Jack, there he is. To the extent that anything today comes across as going smoothly or seamlessly, that is owed entirely to their efforts and despite my best efforts. An extra special thank you to all of the panelists and moderators who've traveled from all over the place, really, and despite grave risk to their health, potentially, and everything else, to be with us here today, and for sharing their expertise with us. And finally, thank you to all of you in the audience, students, practitioners, community members, and alumni, for your interest and for your enthusiasm and for being here today. And for everyone on the live stream, thank you for joining us. In the end, all of our programming is for you. And I hope that you'll catch up with me throughout the afternoon at the breaks or at the reception and give me your thoughts on what we might be able to do for programming going forward, what sorts of things are working for you or not, as the case may be. I look forward to meeting all of you. The topic, the paradox of today's topic, I think, as I was thinking about introductory remarks, is that it is at once really accessible, right? Like, we all listen to music. And even the non-musicians among us would probably venture to say that we'll tell you if two songs sound similar, and if they sound a little bit similar, if they sound really similar. So I think it deceives in its like apparent simplicity at first. It's also really, really complicated. Copyright law, which we'll get into outside of this panel, especially as it's applied to music, is incredibly complicated. Some would say a beast of a topic. Thank goodness for me, because otherwise I might not have this job, right? So it needs to be hard enough that not everyone can do it. Not too easily, right? So it's good job security for me that it continues to be complicated. But music is something that everyone talks about and everyone hears about. So quick show of hands, those of you who've read about Blurred Lines or Stairway to Heaven or the Dark Horse case. All right, so I think that's interesting too, because everyone's heard about it, and if we went around, everyone could give their opinion, right? Yet only a handful of folks, most of whom are assembled here today, have really dug into the nuances of these things. And I think as such, there's a lot of room for misconceptions, for misunderstandings, for misalignments, and we're gonna be working to dispel some of those today, or to figure out which ones we're not able to dispel. In the audience today and via live stream, we have an amazing combination of practitioners, students, academics, policymakers, and importantly, musicians who have nothing to do with any of these things. The point is, not everyone here today is a copyright litigator or has any interest in being a copyright litigator, and we think that's a really good thing. One of the primary goals for Silicon Flatiron's programming, and for the content initiative in particular, is to bring together different perspectives from different backgrounds in hopes of getting to novel, maybe even optimal solutions or outcomes. It's also a good excuse for me to put on my professor hat and offer a couple minutes of background to help everyone hopefully get the most out of the conversations that we're going to be having today. In a nutshell, today we're going to talk about songs. Under current copyright law, songs are protected by two distinct copyrights, and they're unique among other copyrighted material for that reason, right? So every song has a copyright on what we generally refer to as the musical composition, also known as the musical work, right? This could be sheet music, it could be a lead sheet, but it's the composition itself, and has a copyright on the sound recording, right? This is what we actually hear when we listen to the song. You can have lots of different sound recordings on a single musical work. Think of like covers of any songs that are popular that you know, but not the other way around, right? You don't have multiple works for a sound recording. Sometimes these things, like I said, are memorialized as sheet music. Sometimes it's a lead sheet, which vary greatly in terms of how detailed they are. It might interest you to know that the owners of a musical composition and the owners of a sound recording, in some cases, maybe even in many cases, can be and are different parties, right? That that's not necessarily the case, that the sound recording owner is the publishing owner. You can easily infringe a musical composition without infringing a sound recording of that musical composition, right? All of these sort of nuances come into play here. Also importantly for our purposes today and some of the cases we're going to be discussing, copyright law didn't initially protect sound recordings. As a consequence, we have sound recordings fixed prior to February 15th, 1972, which are for the moment subject to whatever state protections are afforded them, but not under federal law. Registration of a copyright, which isn't required but is highly encouraged, requires the deposit of a copy with the Copyright Office for a musical composition. This means the sheet music or the lead sheet, but we'll see today how these facts impact everything from evidence to burdens to jury instructions to objections to verdicts, right? Because this is a significant difference here in the way that they're treated. So we're here today to discuss what at first blush might seem like a really niche topic, right? Substantial similarity analysis of, in music infringement, but which is actually a topic that I believe raises a series of much broader themes. Applicable questions about the proper role of experts and their limitations, for example, burdens of proof and who best bears them, when and why. Policy goals as we apply them to individuals of different categories and to third parties, and distributive justice concerns that are raised when the law applies differential treatment to otherwise similarly situated persons. So I feel like these are more universal inquiries in the law that are really come out in the conversations we're going to have today. Our first panel today will start, I think appropriately, with the music itself, right? We have assembled here working musicians and musicologists who will offer their perspectives on the process of creating music. right? Not something a lot of lawyers spend a lot of time thinking about. Our second panel will feature policymakers of various stripes sharing their thoughts on what is and isn't working, and how, any suggestions for how it might improve. And finally, our last panel will feature some high-profile litigators and academics who are really working in the thick of it to help us see what they see as the biggest issues to be solved or to be more properly understood going forward. We'll take some brief breaks in between the panels. There's some snacks and drinks in the room next door if you need them. And afterwards, we will have a reception in the same room. And I look forward to meeting many of you then. So without further ado, I would like to introduce our first panelist moderator, Professor Joe Fishman from Vanderbilt Law School. In addition to being an expert in the legal subject matter that we'll be discussing today, Professor Fishman is himself an accomplished musician. In addition to his JD, he holds a bachelor's degree in music and a master's in musicology. So he's perfect to handle this panel. And without further ado, I will turn it over to Joe to introduce his panelists. Thank you.
All right, thank you very much. Thank you very much, Kristelia. I teach in Nashville. In Nashville, one of the popular sayings is it all starts with a song, and that's where we're going to start here, with the song and asking, what is a song? So we have a wonderful panel here, and I suspect pretty strongly that we're going to have a lot of discussion and a lot of questions. So I have asked our panelists to introduce themselves, and then we will turn to some discussion. We're going to start with the two artists on the panel, and then we are going to move on to the two musicologists on the panel before opening up to broader discussion. So Anna, can we start with you?
Hello, thank you. It's an honor to be here. I'm so excited about being a part of this discussion, and since being asked to be on this panel, it's been all I've been thinking about. But my name is Anna Morsett. I'm actually a part of the Denver music community and been writing songs since I was like a teen, and have been in bands for the last 14 years, both as a sideman and a guitar tech, and now leading my own project, which is called The Still Tide, and I'm the lead and primary songwriter for that and front woman of that project. Thanks for having me.
Hi, everyone. My name is Jeff Prystowsky, and I am one of the founders of a band called The Low Anthem. We're from Providence, Rhode Island, and I've been playing music and writing songs for 15 years and touring. Toured all over Western Europe and all over the United States with, we got the good fortune of being signed to None Such Records, which was a subsidiary of Warner. And so we were able to tour with Lucinda Williams and the Avett Brothers and the Chieftains, and we opened for Bruce Springsteen and all of this kind of red carpet stuff. And then I've also had the experience of getting dropped from a major label, and then holing up in Providence at in an abandoned theater where we lived and worked for the last 7 years and made it into a music venue. So I've had been on the side of a venue proprietor as well as touring musician, and that's where I last saw Anna. Our paths have crossed multiple times in different bands and projects. So happy to be here and be a part of this discussion. And thank you so much to Kristelia, because the other thing that I'm after right now is I am, like many of you, I'm going to be in law school this fall. So and that's thanks to Kristelia, because I called her up and I said, you know, I just had a kid and I don't think I want to go on the road right now. You think there'd be any room for me in this kind of copyright world? And she told me, you can make a valuable contribution to the community as an artist lawyer. So here I am.
I'm Alex Stewart. I'm a professor of music at the University of Vermont. I've published widely on popular music in the U.S., Latin American music, jazz. So those have been my research interests. I recently returned from a sabbatical in Uganda, which was a wonderful experience. And I'm very pleased to be here. Thank you for inviting me.
I'm Sandy Wilbur. I am a forensic musicologist. I'm also a songwriter and a producer. And I was the expert in the blurred line case on the side of Pharrell Williams and Robin Thicke, and I've done a lot of work in this area.
Great. So Anna, let's start with you. When you're in the songwriting process, do you ever have the experience of thinking that something that you wrote sounds similar to something else that you have heard before? And if so, do you have a personal sense of what kinds of similarity are acceptable and what maybe aren't acceptable? What's okay and what's not okay?
That's a great question. I'm actually in the middle of writing a bunch of new music, which is, well, I'll get there in a second. But yes, I do. I think there's been times when you're like jamming out on a thing and you're like, wow, I really love this. This is so great. And then you're like, that's totally this other thing that I did not write. That's totally stolen. And then you have that kind of breakdown. But I think part of the joy in realizing that this is the song I'm talking about, actually. Came right on. We planned this out. She cued it right in time. So I put that in a song, and I was like, that's odd. That's familiar. But then, of course, like in pursuit of trying to always figure something out new or write something new, I think every time I've recognized anything that was similar to something else, I'd be like, oh, well, that's this thing, which I love. And I'm like, great, thanks. And then try to pull it into your own space, which I think a lot of musicians do. But I guess it's been interesting in writing all this new music recently and having asked to be a part of this panel. I hadn't really thought much about copyright in a greater sense, I guess in the way that we're now going to discuss it. But having been asked to be a part of this panel and writing all this new music, suddenly I got really scared, and I've just been thinking about it the whole time. Well, what if I do this on accident? Now I feel like it's a self-fulfilling prophecy. So in a way, I think the awareness of copyright has affected my writing, just in that I'm more, I guess, in a way, I'm worried about it more, which is interesting, which I never have been, because I feel like every time I approach a quote of a song, I'll alter it, and that's kind of an exciting process to be like, oh, well, that's a Beatles song. Well, let's not play the Beatles song. Let's move this into a realm that I'm still working towards making something new. So it's interesting.
And just to follow up on something that you said, so before preparing for being here today, were the cases we're going to hear a lot about today, Katy Perry, Led Zeppelin, Blurred Lines, were those decisions, even the headlines, were those on your radar at all?
To be honest, not as much as I think they should have been, which is interesting. And then, of course, kind of prepping for this and reading the amicus brief for the Led Zeppelin case, which I'd also hadn't read, I was surprised that I hadn't seen that, especially being a part of a pretty substantial music community in Denver, not having seen that stuff before. Those headlines flash, and you're kind of like, oh, I'll never do that. You kind of push it off, because I think as a band on a certain level, I think it kind of misses your radar. But then as you grow as a band and as your songs become kind of more viable for the, placed other places, then it does become a concern. So I think that maybe is kind of a growing pain of you're just a little dweeb in your basement writing a song, and then suddenly you're in a studio, and then you're with the producers, and then, then it does become a greater concern as, you kind of grow as a band. So.
Jeff, so similar question. Is this something that you think about at all when you're in the process of songwriting? And do you have a sense of, what the ground rules are, what's okay and what's not okay for you to imitate?
Thank you for the question, Joe. So I'd like to begin by just, starting with where music starts for me, which is it's very personal. So for me, it has to do with me and my older brother. So he was always the biggest music appreciator, but he didn't really play. And I was the musician and the creator. So from the beginning of my musical career, it was always this, okay, I had this idea, play something, and then my brother would kind of be the consumer on the other end of that transaction. So throughout my musical career, I've been tracking the evanescence of all of these third parties that come between us. And it's just been unbelievable in the last 15 years to see how you have all of these different labels. I make something, deliver it to the label, and then my brother buys it from the label. How many labels we've been on, or agents, or clubs, or publishing companies, and it seems so evanescent, everything in the industry. And I'm partly here as well to, kind of represent, it's just the two of us who are, trying to represent all these different artistic voices. And so I'm here to, to also learn more about that, for example, to tell a tale, we were signed by this particular team at an indie label called Washington Square, and then they were bought by Concord, and our team was fired. So, you call up one day and you have this point person, and then the next day who signed you, who's been listening to your records, and then the next day they're not there. This is the way that the music industry is, in my opinion, and so it's been, from an artist standpoint, we're looking for things that are durable. You said it all starts with the song. Well, another thing that's been durable throughout my life has been our lawyer. And so the one voice who hasn't changed throughout all of these iterations has been our lawyer. So there's something about the law that is durable through all of these changes. Now let's get to the process here. For me, songwriting is an iterative process. So what do I mean by that? So I mean that these ideas, they kind of go through the function of your mind and creativity, and then they come out, and then you're like, evaluate them, and you put them back in through the process again and again. And it's funny to kind of use these fancy words and talk about it, but I figured, Kristelia, could I use your guitar and just show you what I mean? So we're in Colorado. One of, my songwriting heroes, John Denver. So let's say you take a song like, okay, so I'm jamming out, as Anna says, and now, how can I make that my own? Well, maybe a first iteration is like, almost Denver. I'm not a pop musician in that way of where I'm trying to write to sell, and maybe that's why I found myself in this old abandoned theater for 7 years, working for 4 years on the record that they said did not sound like the Low Anthem when I delivered it. So anyways, but this is the way, I like to write, just, your influence and so on. So anyways, when I was thinking about how to answer the question, to me that was more, and also maybe I'll conclude with this, which is that there's an old Yiddish proverb which says, for every new song there's an old tune, and I thought that was fitting. So that's all.
So first of all, I want to start putting on my business card that it all starts with a lawyer. I like that. Anna, to go back to you, when you're engaged in songwriting, are you typically writing alone, or are you writing with other co-writers?
but then kind of bring it to the band and we kind of expand from there. But I've been in other bands where I've been writing in a group and as a bass player or as just another kind of voice within that creative process. And I was thinking a lot about this because like we all talk about law on this big level, and I think coming from like, you know, being a little guy, let's say, like kind of thinking about our DIY communities and how this affects them. And I think for bands that aren't really seeing a profit from their money, I mean from their, from their music, not money. Like, I guess where does this kind of come into play, and at what point is like, do we start thinking about copyright and all those things? And kind of within that context, I was thinking about these jam sessions where like other people are bringing in their ideas. And I was in a project where the guitar player brought in an idea that was like a blatant quote from another song, like a lick, a riff, that we didn't recognize. And he knowingly brought it in as this like thing, and we're like, that's so great, man, you're so good. And then we like wrote this song, and I think recorded it. It didn't make the record, but it was only after it had been recorded that he was like, oh, that's from this other thing. And I was like, how, you can't do that. Like, you put us in such a terrible position that if someone were to come after us and the band doesn't know about the thing. So I was kind of curious about it from that level, or just even group writing where someone unknowingly brings something in and suddenly you're recording this as a band, and let's say that song becomes wildly popular and suddenly you could be kind of coming up against a copyright infringement that you had no awareness of. So I kind of came at it from that angle of like, where, like, if so, what happens then? And
Does that affect your process going forward? Having been through that, you know, do you now want to ask co-writers, well, it sounds good, but where'd you get it from?
Yeah, which is funny, and I think kind of on that community level where everyone's really supportive and inclusive and all these ideas are open and there's this kind of like all skate feeling of like everyone in together. I think only after that I was like, oh, I didn't realize that I could legally be on the line for something that I wasn't like aware of, which was kind of a confusing and tricky thing. So now in that way I kind of, I mean, and of course like when you're jamming and someone does bring in something, you're like, oh, but that is that Beatles song, and you're like, oh yeah, haha, and then you change it. There's always the change, I think, in any circle we've been aware of anything that we were imitating accidentally, just because I don't think that we wanted to do that, but that was the only time where I was like, oh, that was, and then it kind of echoes your first question of like, at what point is that imitation like a respectful quote, kind of in jazz where you can quote someone and it's like an honorary kind of amazing feat if you can sew it into these lines, you're like, oh, that was it. But with this, is that like respectful and honorable to quote, or is it just a blatant ripoff and something that we could legally be on the line for?
Have either of you working in teams ever had a difference of opinion on that question? Right, you think something's okay and somebody you're working with doesn't, or vice versa?
Yes. Do you have a go?
Yeah. I mean, I have a little story. So, firstly, you know, I really appreciate the copyright law in the sense that I feel like I wouldn't be able to have had all these life experiences if there wasn't this fence around our original compositions, such that there could be a music industry and such that, you know, but at the same time, I definitely am critical of it. And I'll tell you just a little story about how it just came to mind when you were saying that, which is that one time we decided that we wanted to put another artist's song on one of our records. And so we called him up and we said, hey, could we use your song? We love it so much. And he was like, sure, of course, no problem. So we went on to record it and then delivered it to our label and said, hey, this is someone else's song. We don't claim that it's ours. And at the last minute before before the album was going to be released, he came to us and said, I changed my mind. And he held up the release of the album because we couldn't get this permission. So this it's just a little story, but it really did happen to me. And also to show you about how things can get kind of ugly in the music business, is that he then said that he said, I will only give you permission if you let me open for you on the tour. So he like used that leverage to then, so the music industry, it's, but you know what? But maybe law will be just the same when I go. No, I'm kidding. But yeah, but I wanted to just to share that how, you know, and towards the criticism, I think also when Kristelia first wrote me the email and said that this was a conference about content, like content conference, I just like, I don't like being content. I just have to say that, you know, part of the criticism, like that's part of the reason why I want to get out of this like, I feel like where the industry is going with, I'm sure, okay, how many people use Spotify? Okay. See, so like, I'm not getting paid for this very much, and so I'm thinking, you know, this idea that, okay, I'm going to make another record and put it out there as, you know, as this kind of like, and add to this content where I'm not seeing a return. I'm seeing inconsistent royalty streams, and I'm seeing, you know, people more and more coming to me with other free promotion ideas for me to pursue, and that's really hard, especially for someone like me who's a new father and has other kinds of responsibilities that needs a kind of durability. So, anyways, just wanted to bring that up as well. I know I knew streaming was on my mind and I wanted to bring it up, but I definitely have seen throughout my career. I started back when we were, you know, it was like CDs and CD Baby and all this stuff and Tower Records, and now all the CD stores are closed, and the music industry has really flipped. There was no Spotify, there was no Apple Music when I started. So I've just been like, what is happening? Why is my income going down and down and down and down? And so part of my desire to get into the law is also, you know, I would like to help serve artists and help them accomplish their goals, and you know, because it's really getting hard out there. And again, I'm not speaking towards this. I think that this particular problem that we're talking about today is really a problem when you have the money to hire lawyers and so on, and you're at a certain level of pop music. As evidenced by the cases we're talking about. We're not talking about, you know, some little person, you know, here and there. We're talking about, like, you know, Blurred Lines and Pharrell Williams and all these like kind of superstars and whatever. So I just wanted to bring that up as well. You know, who could be sitting in our seats, I think, is maybe like someone from the Marvin Gaye estate, or it could be, you know, Robin Thicke or something. Like, it's them, they'd be like, yeah, like I couldn't get that yacht because of this stupid case, you know? But for us, I think we're providing this different perspective that really is more of a working artist perspective.
Yeah, so much of this is about power dynamics, and I want to come back to that during our discussion afterwards. But so speaking of the cases, that's a good segue to turn to the second half of our panel here. So Alec, let me start with you. You know, if you are a musician or a recording artist, you're not necessarily holding yourself out as an expert on musical similarity, but you and Sandy are holding yourself out as experts on that question. So how do you think about similarity between two pieces, and does it match up at all with what Anna and Jeff have been talking about?
That's a good question. As you probably know, in the law, there are two tests: the intrinsic test, which is the lay listener test, and the extrinsic test, which is where the experts come in, which is supposed to be the objective analysis. And so many of the cases that are presented to me obviously have some similarity, or they wouldn't be approaching me with the idea if they're a potential plaintiff. And I find that well over 90% of these matters, I have to tell them, no, I don't think you have a case. So they're really different tests. I mean, something that sounds similar to the ordinary listener, the average listener, won't necessarily at all make it to the standard of you know, being substantially similar under the extrinsic test.
And so it looks like you have some examples here. Could you walk us through how you would think about, in a particular case, work A and work B?
I have some slides here. Maybe it's a good time to go to them. So I was going to take a look at a case that I was not involved in, which makes it more comfortable to talk about. And this is, of course, the case that's been in the news most recently, Gray v. Hudson, or the case, Dark Horse case, as everyone refers to it. And I'd like to emphasize again, I have no horse in this race. Sorry for the bad joke, but I'm not involved in this in any way. But I'm trying to understand better how this verdict was reached. And so one thing to keep in mind is that these cases are not decided on the music alone. So often there are other factors that come into play, things that happen inside or outside of the courtroom. So I find that at musicology conferences and so forth, everybody's always talking about, well, how could this have been decided this way? You know, the musicology doesn't back that up. And the fact is that there's a lot of other factors that come into play in a trial. How sympathetic one of the parties might be or unsympathetic to the jury. Rulings that are made in the course of the trial, evidentiary processes, and so forth. Now, one of the things that became critical in this case was the access question. You know, did Katy Perry and Dr. Luke, the songwriters, have access to the Christian rapper's song, Joyful Noise? And on the basis of the fact that Katy Perry's parents are traveling preachers, they thought there was a connection to this Christian release that she could have heard it. At least that was one of the main arguments as I understand it. I'm not going to talk about access today because that's not something that musicologists typically get involved in. We're talking about comparing the actual music. And so the first step in comparing the music, for me anyway, is to put it into music notation. But even that is not always purely objective. You'll find that different musicologists will come up with different transcriptions of the same music. So I wanted to look at 4 different depictions of the ostinato that was at issue in Dark Horse. An ostinato is a melodic pattern generally that is repeated over and over. So let's look at these 4. Each note has a articulation to it, has an inflection at certain points in the pattern. So it's do-dee, dee, 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 da, da, da. You all heard that, right? So in the defense's expert transcription, he wrote those inflections as actual notes. And if you look really closely, you can see that there are some little lines written there to indicate glissandos, that it's a slide. But it's really not apparent to somebody who was not really paying close attention. It looks so different from Dark Horse, doesn't it? Because of the way it was depicted there. And in the Amici brief that was filed in support of Katy Perry, the glissandos are not even indicated at all. The glissandos in Dr. Ferrara's transcription are there, but you can barely see them. But in the Amici brief, it's not there at all. So that would be do-a-da-da-da-da-da-da-da, with distinct pitches, distinct notes. But interestingly, the plaintiff's expert, and this is maybe the first case where I've ever seen this happen, didn't use music notation at all. And that really shocked me when I heard that. But he used this chart down here using these integers for each pitch. One transcription up there with the notes highlighted in red that are the same. and I use those little marks to indicate the inflection. Let's listen one more time to that it doesn't have those inflections, so there was no kind of disagreement over that. How many think the first transcription gives the best visual representation? How about the second transcription without any glissandos at all? Figures, Dr. Freundlich. My transcription? Yes! And then how about the plaintiff's expert transcription? Yeah, okay. But I do this really not to, again, like I don't want to beat a dead horse here, sorry with the horse jokes. But I'm just, this is what we do as experts, is to try to put it into some more objective framework rather than just, oh, this feels the same, it sounds the same. It's the same groove, which can mean a lot of different things. One more quick thing, I had some other things to talk about, but let's listen to the rap section in Katy Perry's song. What do you hear during these sections of these songs, which comprise, like, in the case of Joyful Noise, that's the majority of the song, almost the entirety. And in Katy Perry's song, it's a very substantial part in the center of the song, the rap section with Juicy J. What do you hear besides the rap? We hear drums, we hear ostinato, we hear the rap, and then we hear some sort of ambient grunts. That's it. That's the entire track. So I want to just...
quality of the instrument that are playing those notes, or does that not enter into your thinking?
To me, if the notes are similar, then we also look at some of these other aspects because they're part of the composition as well. Mm-hmm. But obviously, I would not think it would be conscionable to bring a case just because it's a similar sound and the notes are different. You can't copyright a sound, in my opinion. This is Dr. Katie Leo, who's a professor at Millikan University, who did her PhD thesis where she talks about the melocentric approach in music copyright. And so there's this is a quote from the brief that was filed in support of Katy Perry. It says, the most important elements of a musical composition are melody, harmony, and rhythm. It's typically the most distinctive and memorable musical aspect of a popular song and musical works in general, because melody is what listeners readily comprehend, recall, and replicate. So what would you recall and replicate from the rap sections that we just listened to? da, 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 da. That is the most memorable part. So I think that something that bothers me a little bit is the idea that an ostinato in general is too secondary to ever be important enough to be protectable expression. I don't really take a position on whether there's not other prior art out there that would disqualify this for being protectable, but I don't think we can wholesale say that an ostinato is not protectable. I mean, to me, I know this is the most memorable part of the song because last night I couldn't sleep all night. I just kept hearing da, 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 and I wanted to shoot myself. So it's one of those earworms. And so I'm probably out of time, right? But I'll just make one quick point. This is so common in contemporary pop music, this sort of minimalism now, where you have nothing more than a rap, a drum beat, and some ambient sounds, and an ostinato. And there are songs, I could give you some examples, where there's no harmony, there's no melody anywhere that could be transcribed like what we just looked at. There's not even a bass part in some of these songs. So my question is, when you're dealing with this kind of minimalism, doesn't that also elevate some of this musical content in importance? And I throw that question out there, and I'm eager to hear what people think about that.
Great. Okay, Sandy, how do you think about these issues?
Oh.
Oh. You can't trust him.
I didn't attribute it to anyone. I didn't know who wrote it.
I thought it looked familiar, but yeah. Well, so how do you think about similarities, Sandy?
I think you have to take the musical work as a whole, and then you have to really focus in on the similar areas. And many times they're melody, many times they're a combination of melody and lyric. If two songs have the same melody and the same and similar lyric phrases, that's more problematic. But you see, pop songs are a lot of melody and lyrics and a lot of chords. You can't copyright chords in and of themselves or rhythm tracks in and of themselves, but in combination, they can have more meaning. But I would say that as rhythm has become much more important from the Afro-American point of view, and rap has become so important, that a rap, and we just settled a case with that, with the same phrase used and the same intonation and the same place in the measure.
Was it the same lyrics too?
It was the same lyrics. And there were so many similarities to this that it was very difficult to say that this was independently created. And on the other side, they had a lot of prior art examples, like about 35. But I'm sorry, I don't want to keep going.
Hey, just take the slide down.
Okay.
Yeah, I didn't want to leave that up there.
But none of these 35 examples.
Oh, no. It won't go away.
I'm my own form of earworm.
Oh! I'm sorry, I'm interrupting things.
Life finds a way. Anna, did you have slides as well that you wanted to?
I have slides.
Okay, yeah, you can put. Oh yeah.
Sorry.
Okay. Shall I go?
Sure, go ahead. Yeah.
Okay. Let's see if we have my slides up. Let me see if this is it. Yes. Okay, so now I have to be able to play it. I'm going to need some some IT help, I think, on this. Can we put this into play mode?
This is, you opened the PDF.
Oh, I did. Okay, sorry. Where is it? Here it is. Okay. Sorry, all. And the pointer is, okay. How do I, this isn't working and I don't have a pointer. Or you know what, let me use my own pointer. Sorry, guys. Oh boy, this is going to be tough.
I think there's, but
Thank you. Okay, let's see if this works. Turn it on. Yeah. I'm trying to use this so it changes the slides. Yeah, you have to put in that thing, yeah. Okay, all right. Okay. I tried to answer the questions that were brought up by Professor Fishman. Is your forensic practice getting busier, or is it business as usual? It was much, much busier. I do about 300 to 400 jobs a year. Most of them are preventative. In many cases, they were advertising agencies and film companies. Now what's happening is that the record companies and artists are having this problem. And so you can see, the job of a forensic musicologist is to be able to accurately find and transcribe in any form or notation or graphics the similar musical and important non-musical facts in the work and be able to show, explain, and demonstrate what those musical facts are to an average non-musical listener. So in a sense, I'm teaching people how to hear it. And I'll show you some slides that try to show that. I'm going to, I'm looking at a piece and determining whether what is important, is it original, is it substantially similar, is it strikingly similar? There's always a question of prior art, which means things that come before the two pieces that you're analyzing. And always the question that comes to me philosophically is, what is original, and can you own that so that nobody else can ever use it? There are different genres of music, and there are common elements in those genres. Certainly country music tends to be more lyric-driven. Folk tends to be more lyric-driven. Blues is much more of a performance kind of thing. So each type of music you have to look at separately and see what is important and what are those things that are the same. And sample analysis, by the way, which I do a lot of, is a very different animal. You literally decompose and recompose the sample to see if, in fact, it really came from the original source. But I'm going to move quickly. This is a wonderful site for all of you, if you don't know this already. It's the Music Copyright Infringement Resource. And I put together the last 20 years. And I think you can see very clearly that in 2000, now, this doesn't mean all the cases that were ever done. These are what they have put on this site. But you can certainly see that there's a lot more from 2016 on that have made music copyright incredibly difficult and confusing. Here are some of the cases that affect creation. The Beach Boys, I'm going to run through this quickly. First major plagiarism case. George Harrison was the first unconscious plagiarism. The John Fogerty was the first case of accusation of copying yourself. It also was, it really also established that if the other side has no basis for having, in a nuisance claim or something like that, then attorney's fees can be rewarded to the prevailing party. The Vanilla Ice is a hysterical example of sample, and I don't know if any of you have seen it, but if you haven't, you have to try it. It's hysterical. De La Soul, what happened is that as samples became used more and more, people were basically put on alert because it costs a lot more to license a sample, and not only that, but damage. So interpolations, which sound like the sample but are not, are created, have been used more and more. I would say that that is changing as well now because interpolations are sometimes going over that too. Two Live Crew is an important case because it was fair use and parody could be used as a defense even on a commercially released recording. Fair use, interestingly enough, after the case was decided, they did settle, and Two Live Crew did license the piece from the publisher. Led Zeppelin, there is a question, there's an effort to apply the 1976 Copyright Act to the song, which falls into the 909 Act. I don't know how that's gonna go. The next one is Uptown Funk, and there have been so many claims, and so many of them that actually I didn't think were merited much, but there has been a lot more cases brought, and it's easier to settle those cases than have to go into litigation. Economics really plays an important role. If you don't have a really hit song, you're not going to get sued. But if you do have a hit song, you very much likely could. This is an example of some of the new creative songwriting ideas where they have a track that you listen to this and tell me what you think are the same. The track. The person who did both of those tracks was the same person, and there are producers producing beats and tracks. They're slightly different and I'll show you where. If you look at the chords, the second chord is different, but you certainly do have the most common. Let's just listen to this and let's use the pointer here. The other one, I can't point, unfortunately, I don't know how to do it. Both of these have extremely different melodies, although the chords and the tracks are very similar. And the one that was created for Already Gone is one of the most popularly used chord patterns in hit records. And if any of you want to look for axis of awesome, you know who I'm talking about? It's, okay. The 4-chord progression that every single hit seems to have. Okay, this is another example of the kind of songwriting that's happening. How many of you know Old Town Road? Okay, so you all know the story of Old Town Road too. Well, this obviously was a track that was bought online for $30. I'm just going to play a little bit of it. It uses an 808 drum sound, which is very characteristic of trap hip-hop pattern. It also contains a sample from Nine Inch Nails with limited distribution. But after it hit, they negotiated a much more appropriate. Okay. Again, another question I tried to answer. Do all of these recent judgments seem like, a natural extension of everything you've done? Well, no. There's a lot of confusion. There's significantly more artists, songwriters, and producers wanting to make a claim against a hit song. At the same time, more labels, artists, songwriters, and producers are increasingly moving toward prevention or insurance, because these things are coming out of the woodworks. Jury trials are exceedingly unpredictable, and the results can be serious and sometimes unintended. Music copyright infringement cases are complex, and one of my recommendations, and I've actually done this, when there was a case several years ago, the judge in California basically said, I cannot understand what these two experts are talking about, and I need somebody, and you two have to decide who that is. And I was selected. And it took about 2 months for me to research this before I could come up with an opinion, which neither side was happy with, but at least it was what I felt was the case. In all of my preventative work, if the work points specifically to any artist, musical work, or group, or if you use a reference track or are asked for a quote to license a musical work, or were denied a sample use, you really could have a problem. And so for me to be able to, quote, clear those pieces of music, I highlight where the problems are, and then they have to change them before I'm going to clear it. Do we have time?
We're about ready for the Q&A portion.
Okay. Ooh, okay. Then I will not do this.
All right, so I have a ton of questions, but I know that probably people in the audience do too. So I'm going to pass the baton out this way. And if, particularly if any students have questions, I would love to begin there. Okay, I see one hand up. Yep, go ahead.
Do you guys think that juries made up of non-musicians are competent enough to? Yeah. Okay. So in cases that hinge on highly technical musical analysis, as musicians, do you guys think that juries made up of non-musicians are competent enough to decide whether there's infringement?
I'll be happy to answer.
Well,
I actually do not think so. I think it's very difficult, particularly if a jury is not familiar with a genre. You have a very short amount of time to teach them how to hear, and you put the graphs up. But the fact is, my feeling is that the first time they hear the pieces is when they form an opinion, and then there are other non-musical issues that come up, like in Blurred Line case. Robin Thicke was not a sympathetic character. In that case, there weren't two consecutive notes that were the same. But the jury made a decision, I think, based on non-musical facts that had a lot to do with Robin Thicke.
I agree. I think that is often, these intangible things that can come in play in a case. But I would disagree with you about whether juries are qualified to make these decisions. I think my job as a musicologist is not only to present the technical side of it, but to be able to put it into layperson's terms. So I think part of what we do is, in sort of an adversarial role, is try to make our cases to the jury and see, the jury will decide which expert they think is the most convincing. And you know, I teach a lot of music courses to undergraduates who have no musical training. So I kind of feel like I've gotten a lot of experience talking to people who are not musicians about music. And I think that's an important skill that you need to have if you're going to do this kind of work too.
I'd like to defer my answer to Kristelia because I read a paper that you wrote where you had answered this question.
Hi. Sorry, I was saying I don't know if I have an answer, but I will mention some proposals that might get talked about in the next panel. To the extent that juries find this difficult and complicated, well, one thing you might say is juries find lots of things difficult and complicated, and we still send those things to juries, right? So, you know, if we can send murders, perhaps we can send these. That said, you know, proposals have been, you know, should we have mandatory arbitration where it's being arbitrated by panels of musicians? There are problems with that as well. Could this something that could be handled in small claims court? Well, plaintiffs don't want that, right? Because they're not looking to cap their damages. Could we have independent, neutral, court-appointed experts, as Sandy was mentioning? Maybe that's an answer. So there are other possibilities if we feel like this is particularly ill-suited to juries, but you know, noting we also send pretty highly complicated patent cases to juries too. So to the extent juries aren't doing a great job, it's not just a copyright problem.
So this is directly related to the similarities between the Kelly Clarkson and the Beyonce song. So a friend of mine runs a place called the Producer Dojo in Los Angeles. And I want to draw a bit of an analogy, which is to say the decreasing costs of production these days are in one sense very democratizing for musicians. Many people can actually have a studio on their laptop at a very low cost compared to what previously was the case. That being said, there's high levels of convergence towards certain dominant platforms or software suites for music production. And there's huge demand for sound packs and sample packs. My friend actually makes a considerable amount of money making those sample packs for Ableton. And so in one sense, there are more chefs potentially in the kitchen. But in the other sense, the set of ingredients that go into recipes and the set of ways that those recipes can be created are actually converging to a lower number. So my question is, do you think that actually there's more likelihood of infringement if all of these budding bedroom producers are drawing from the same sample and sound packs on the same audio platforms, and they're not engaged in the direct production of sound itself, but compiling those ingredients together in likely to be increasingly similar combinations?
I couldn't agree with you more. I mean, basically, there's a proliferation of sample libraries, track libraries, one of them I mentioned, but there are scores of them, score. There are lots of them. And I'm asked to comment on some of these many times because these third-party companies are getting these things from other people, and they're not really guaranteeing anything. So I think, and certainly I've found several of them that were too close to hit songs that were problematic. So I agree with you that this everybody wants to write a hit idea and use the same kind of things is problematic. In the case, the case that I showed you, melodies and lyrics were so different, it didn't really matter. I felt that there was no problem with those.
Turning back to what you said earlier about overcoming an issue with the jury's unfamiliarity with a particular type of genre of music, is it advisable, in your opinion, to perhaps play a series of sample tracks that aren't at issue in that genre temporarily familiarize the jury with the genre so that when they hear the two tracks, they don't just sound the same because of the fact that the jury's unfamiliar with the genre? Is that something that you would explore as in presenting something like that to a jury?
Well, remember, what we do is to teach people how to hear. And if that's something that could be used, that's fine. But many of the cases right now are songs that are in the 1909 Copyright Act, so they were recorded before 1978 when you had to have a deposit copy at the at the Copyright Office. So if it's a recording that comes after that, then absolutely the sounds that's a useful thing to do in a particular case. I mean, again, I'd have to see what the specifics were.
I would just say that I've been involved in a couple of trials involving hip-hop songs in Nashville, and the jury was, in both of those instances, was not really familiar. Most of the jury was not that familiar with the genre. This was in about 16 years ago. They'd probably be much more familiar now. But I don't think it was really an issue because we were really dissecting the music to the point where I think they were able to distinguish the musical expression that we were talking about, the experts on each side, and really focus on that.
We have time for one more question.
Hi, my name's Daniel Abad. I should say off the jump so that nobody thinks they're being ambushed. I work for a music publisher that represents a portion of the work, Thinking Out Loud, and I'm aware that there may be people up here who are working for the plaintiffs in that case. But I just wanted to ask generally to the musicologists what your thoughts are on the use of mashups as evidence, and if that's, dirty pool, a way to trick a jury, basically.
I'm going to give this to you, but we totally agree that mashups are bogus.
They're misleading.
Yes.
They are just completely inappropriate, unprofessional, and they should be abolished.
Yeah. God. People send me mashups. I say, I don't want to even hear these. Send me the original tracks separately.
The bottom line is you can change the pitch. You can change the tempo, superimpose lots of things, and it just means that harmonically they're either compatible or they're using the same chords. It means nothing else. And it's very misleading, and particularly for juries who really don't understand music. It's just not appropriate. I hope that answers your question.
We agree.
Well, congratulations. We've reached consensus, so I consider this a job well done. So please join me in thanking our panel.